When it comes to estate plans, one plan does not fit all. Unfortunately, the estate planning industry would often have you think otherwise. So, this is the first in a series where we're going to tackle life stages and look at what's really not just the planning package, but the planning process look like optimally within each of those life stages. So, today we're going to tackle young families. So this is a presentation and series for individuals who might be struggling with the estate planning process, especially young families, or advisors or attorneys who really need to learn about the soft skills of estate planning. So we're going to kind of break this down into, like I said, life stages and look at this in a series. But today, we're looking at the demographic of parents of any age who have children who are under the age of 18. So how should the estate plan take into account the needs of both generations? Now, with this series, I'm going to repeat this common refrain. It's a misunderstanding. Estate planning itself is not commoditized. That's often pitched, but estate planning attorneys themselves are commoditized. This is something that's baked in since law school because attorneys are taught to be the same. And it carries into the practice of law because our professions and the various bar associations within the profession of law self-regulate and create pressure to be the same as well and not stand out. But this presentation is also for those who want to stand out and push back against that pressure. So today's episode 214, is One Estate Plan Does Not Fit All, Part 1, Young Families. As always, this presentation is not intended to substitute for legal or tax advice and is provided for educational purposes only. So a little bit about me. My passion is education. I'm also an estate planning attorney, so I deploy both in separate buckets of my career. So if you're a client in Colorado or Tennessee in need of estate planning services, you can email me at gbridgers@hutchinslaw.com, or if you'd like to leverage estate planning education for your practice or your group, you can email me at griffin.bridgers@gmail.com. Now back to the presentation. So, most estate plans really consist of a package of documents. And this is really kind of the commoditized part, but this reflects more the commoditization of the attorney and not the documents themselves. So for a married couple, there's usually one document for each individual in this set of categories. It will typically have a will for each person, a medical durable power of attorney or healthcare proxy for each person, a living will for each person, and a general or financial power of attorney for each person. There might be some other documents thrown in, like funeral instructions and even guardianship documents like we're going to look at in a bit. But sometimes plans also can create a revocable living trust, which is designed to take the parts of your will that deal with how your property is disposed of and shift those from the will, or the function of those, from the will to the revocable trust itself. So the will then just becomes a necessary component to funding the revocable trust, but that's all it does. It funds a revocable trust and names certain fiduciaries, one of whom we're going to talk about in a bit. Now, with a revocable trust, there might be one for each individual in a married couple, or sometimes you might have a joint trust for a married couple, which would be common, especially where community property is involved. Now, with this estate planning package in young families, it's important to note that this package tends to be the thorough end goal of the basic estate plan, and there could be added icing on that, for personal transfer tax planning, personal asset protection planning, and personal business succession planning above and beyond those basic documents. But for most estate plans, at least top of the bell curve, those are the types of documents that you're going to end up with. Now, I want to emphasize here that with a young family, it's always important to be thorough. But we live in an era of unbundling legal services and tackling things a la carte, eating an elephant one bite at a time instead of looking at how do we eat the whole element. Now, the desire for thoroughness is often one-sided. Now, guess whose side that comes down to? If you guess the attorney, you're right, because the attorneys want to protect their hide and make sure they're thorough so there's no legal liability down the road, and cynically, attorneys can charge more for a complete estate planning package and for thoroughness than they might be able to if they really emphasize the process. But the cost of pushing a thorough estate plan is that it makes the client reluctant to get started because it requires a much higher upfront investment of time, of fees, and more importantly, emotional and psychological energy. So, my big question to everybody out there, whether you're a client or a professional, is what's better, to get started or to be thorough? Now, obviously, you're going to pick to get started, but some of you might pick being thorough to protect your hides, and that's okay, because that's the way you're wired to think if you're an attorney. But my analogy, especially for those of you who advise young families, or if you're a young family itself, is that if you were a personal trainer, would you tell your clients that they must go out and run a marathon to get started, and that anything short of that is a failure? The answer is no, nobody would do that. So that's how I want estate planning for young families to be tackled here. That what's more important is creating a habit, and when you're building habits and taking steps, it moves this from a package to a process. And I think this applies to anybody in any life stage of estate planning, but especially for young families, what I want to emphasize is that really it's the process of estate planning. The package approach tends to say that there's a one-size-fits-all approach and that it's a set-it-and-forget-it approach, that you can just do some documents once and throw them in a drawer and be done. And I see too many people come in who've done a will 20 years ago and haven't touched it since, and it's completely opposite of where they're at. They might be divorced, they might have additional kids, their kids' needs might have changed, and this basic will they did years ago no longer addresses what they need now, because estate planning is a process, it's not a package. So the difference is how you position that process to yourself or to clients, and looking at that. Your goal is building up to eventually running the marathon, but you have to start small and take encouraging steps, which help you to gain momentum in that process, because action over thoroughness is encouraging. Thoroughness over action is discouraging. So for a young family, there's really three primary goals, and I've listed these in order. One is control of the guardianship process. Two is control of the conservatorship process, which is top of mind right now with the news of Britney Spears. And then there's a third that may or may not apply, but is the X factor and warrants its own separate discussion, and that's expected inheritance. So the process of planning for a young family should keep these goals in mind, along with the order of importance in goals. You can't tackle all of these at once all the time. It is difficult and sometimes requires cooperation with older generations, which you may not have. So, with that being said, top of the list, I think, for anybody is just simply getting control of the guardianship process. Before anything else, any parent with young children needs to do this, because you have to name guardians for your minor children before anything else. Now, the good news is that this is simple to do in a lot of states. It doesn't always require a will. You can do this in an outside separate document. And it doesn't involve a lot to get this document in place, and I think any attorney who doesn't just simply offer this as a service at a low cost or even free is doing clients a disservice. You're not serving young families if you can't just easily and quickly wipe out this step if you have a young family come in. Now, it depends on the state as to whether you can do that outside document. Some states you can, some states you can't, but in those states that you can, this should be, something that no client ever walks out of an attorney's office without, as far as I'm concerned. Now, the hard work is on the client side, because psychologically there are some hard questions you have to deal with in this. Now, this is a one in a million thing where both parents are deceased or incapacitated, but you have to dig into the guardians who would kick in after that point and who they might be. So for one, you have to look at some hard questions. For example, do you want your kids to stay in the area where they are, the same school system, same neighborhood, or do you want them to move to where your guardians are located, who may be in a different state, maybe across the country? Is that going to be damaging to the kids to uproot in a time of grief? Also, you have to dig into, the guardians themselves. For example, If you name a married couple, usually maybe a sibling and a sibling-in-law, as your guardians, what happens if they divorce or one of them dies? It's usually better to maybe name one of them as guardian instead of both, and not condition the guardianship on marriage, because you don't want your kids also caught up then in a custody battle down the road. And the biggest one is, how do you fund the care of your child? Young families usually don't have a lot of savings, so because of that, life insurance is almost always important here. But it's as a wealth supplement and not a wealth builder. Now, I could talk for hours on the life insurance industry and the disservice they do in distinguishing those two, but that's neither here nor there. Now, conservatorship process becomes more important for the financial aspect. Now, not every state recognizes the conservator role, but this can kick in not just when both parents are deceased or incapacitated, but even in a situation where maybe one parent is living and life insurance pays out, or maybe if you have a child who receives an inheritance from an older generation, or even their own earnings from services they provide, or even from artistic ability. And once the child reaches the age of 18, the conservatorship could be abused. Case in point, Britney Spears right now and what's going on. So what you have to do here is, you can't always avoid this, but you can at least try to control the process by having a child's inheritance payable to a trustee instead of to the child directly if the child is under the age of 18. And even once the child reaches age 18, depending on life stages, it may still be important. You're really doing children a disservice if you can't build in this easy protection, but that's a subject for another time. Now, where it gets complicated is that this has to also be tackled in phases. So being thorough tackles all of these phases, but it's a process to look at each of these in turn. Sometimes it's better to just get a simple trust in place that provides for the child's basic needs. Then from there, you can look at life stages. What are the needs of the child when they're under the age of 18? Can a guardian benefit from those assets? When the child reaches the education phase in college, what are their needs then? When they reach the career phase, what are their needs then? When they reach the marriage and young family phase themselves, what are their needs then? And then ultimately retirement comes into play as well. Now, controversially, I believe it's too much to bite all of these steps off from the beginning, but it's still part of the process, and this is where the disservice comes in. You don't get to set it and forget it. You need to always be thinking about the trust for your kids and what the terms are and building those over time. Now, for family inheritances from older generations, if you're lucky enough to receive that, and have that privilege, attention should be paid to the matter of wealth transition. Now, this is one of those where there's a lot of competing viewpoints, because attorneys typically have to represent one generation. So because of that, children and grandchildren rarely get input into the estate plans of their parents or grandparents or older generations. But I think this is going to be the next great frontier in terms of practice differentiation and training for attorneys and advisors. So because an attorney represents one generation, the younger generation often doesn't have a voice in the transition of wealth from one generation to another. And cynically, this is the constant generational battle between young and old, but unfortunately, we live in a world where claiming a voice, if you're younger, is often considered to be an attitude of entitlement, but at the same time, it's that exact trying to claim the voice that does lead to a lot of estate disputes and a lot of anger when wealth is transitioned from one generation to another, especially for family businesses. So this subject is going to warrant way more discussion than what we can provide here on one slide or even in 10 minutes, but I think it's important for the context of young families to look at its expected inheritances and look at how the inheritance from older generations to the younger generations might accomplish the goal of guardianship control and conservatorship control. So lots of factors to take into account, but I hope this creates a holistic view of planning for young families and can encourage attorneys and advisors out there to look at the process instead of the package. As always, if you have questions that aren't client-related or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. But thank you for listening to this episode of 10 Minutes with Griffin, and I look forward to seeing you in the next one.